Welcome in, guys. Welcome, welcome. I will just give it another minute to trickle in, for people to trickle in. Excuse me. All right, well, I'll go ahead and get started. We have a number of bills to go through today, so I don't want to waste too much time on the front end. All right, no one's allowed to chat me during this. Okay, thank you guys for joining. Good afternoon. My name is Chelsea Hoye, Director of Government Affairs for the Iowa League of Cities. And I'll kick things off real quickly just with a couple of housekeeping items. The webinar is eligible for IMFOA and IMAA credit. I see a couple hand raises. Are we worried about that? Can you guys hear me okay? Okay. All right. All right. So, couple of so IMFOA credits, IMAA credits. Those codes will be given to you after the conclusion of the presentation, and this will be recorded for folks who are unable to join us today. Okay, you can hear me. Perfect. You're getting an echo. I don't know why that would be. Okay. I'm going to keep trudging along, and Mike, let me know if something comes up. All right, we'll go ahead and get into it. Okay, so we have a number of bills to get through today. Like I said, I'm going to throw this in the chat if I can. Maybe I can. So this is just our new laws publication for if you want to follow along this way. Thank you. Okay. All right, so the big one that happened this year that we're not going to spend a ton of time on today, because I know many of you likely joined us for our dedicated property tax webinar back in early June. So I'm not going to spend, like I said, time walking through all of the provisions. So this is a summary. But instead, I did just want to provide you with a brief update on some of the things that we've learned working with our partner stakeholders in this endeavor. So that being Department of Management, Bond Counsel, Piper Sandler, one of our partners, and city officials across the state. So I'll start with Department of Management. Throughout the summer, we've had a lot of back and forth with DOM folks, and they've made a couple of things clear. So they intend to provide implementation guidance through memos, presentation, webinars, and FAQ documents rather than formal administrative rulemaking. Guidance has been rolling out in phases, so you may have already seen some communications from the Department of Management. I know Iowa State Extension has also been in communication with them, so there's been some of that collaboration through their presentations as well. But additional guidance will continue as cities move into the fiscal year 2028 budget cycle. But as always, when we receive new guidance from DOM, we will share it with membership more broadly. Bonding. One of the bigger areas of uncertainty this summer has involved the bill's new bonding restrictions. So we've spent a considerable amount of time discussing these provisions with Bond Counsel because understandably, cities want to know exactly what qualifies as a capital expenditure versus an ongoing operational expense. One important clarification we've received is that engineering or professional staff time that is directly and solely attributable to a specific debt financed capital project may still be financed with bond proceeds, provided that the work is carefully documented. So you'll want to make sure that you're doing that documentation appropriately, and maybe speak with your own specific legal counsel on that. But on the other hand, general department payroll or other routine operating expenses cannot simply be paid with debt financing. All right. Let's see here. Piper Sandler, we've continued to work closely with our partner organization, our partner Piper Sandler, as they continue their long-term financial forecasting models for cities. They're incorporating the final property tax legislation into this model. If you remember throughout session, Piper Sandler did a great job of doing a kind of a side-by-side comparison of what the bills, what the results of the bill would have produced for cities across the state. And so they're working on building that into, based on the final package. They are also working directly with the Department of Management to better understand new reporting requirements and how future growth rates should be modeled. Those conversations have taken just a little bit longer than anticipated. Everyone wants to be sure that the underlying assumptions that are fed into the model are accurate. Travis did share with me just last week that they're getting pretty close, and they're optimistic they'll have something to share with us in the near future. So I know it's frustrating that everyone wants specific answers on implementation. So I would just encourage everyone to think of this implementation as an ongoing process rather than a single event. The law has technically, certain pieces of the law have gone into effect, but the practical details will continue to be a great deal of collaboration with Department of Management, financial advisors, the counties, bond counsel, etc. And so we'll be sharing those answers as they become available. But one thing I've really appreciated over the last couple of months is that everyone really recognizes the importance of getting this right, rather than getting something out super quickly. So hang tight as best as you can. We'll get you those answers as we can. And then here also on this slide is a QR code if you'd like to go back and watch that webinar. All right, so we'll get into the bills next. Starting with some in city administration. So this is a big one that we've gotten a lot of questions about from our city clerks and finance officers. Since the bill passed, one of the most common questions we've received has been exactly what constitutes a city's primary internet site or internet presence. Fortunately, the Iowa Public Information Board, or IPIB, recently issued an advisory opinion that helps answer some of those questions, and that opinion was formally approved by the board. I believe it was just last week. So the annual designation requirement applies to the physical posting location, and if your city already has a location designated by ordinance or policy, you can continue to use that location. IPIB recommends that cities still acknowledge that location annually for the purposes of Chapter 21. For electronic notice, the advisory opinion clarifies that a city needs only to post on one designated primary internet site or presence, not every single platform or web page that the city maintains. So if your community has both a website and a social media page, you only need to post that to one of them. And I think probably the website makes more sense there, but that's up for you to decide, IPIB. The opinion also confirms that if a governmental body does not maintain a website or internet presence, this statute does not require you to create one simply to comply with the provision. So if you don't already have a social media or website, you do not have to, you are not required by this law to create one. Let's see. And while the law does not require an annual designation of the city's primary web presence, the board does recommend doing so as best practice to improve transparency. So this is a really good example of how implementation continues to evolve over time. And so as agencies issue guidance and advisory opinions like this, we will continue passing along this information so that you can do your best moving forward. Let's see here. All right. Property owner protest rights and zoning changes. We've also received a number of questions about this one. So this bill amends Iowa's zoning laws to allow city councils to impose conditions on property owners during zoning changes if agreed to in writing. It expands the needs of individuals affected by zoning variances to appeal to the city council and allows the city councils to overturn Board of Adjustment decisions by a supermajority vote, which is a pretty significant change from previous law. Let's see here. This statute creates a brand new appeal process, but the law unfortunately does provide pretty little procedural guidance. Legal counsel that I've spoken to emphasize that there really is no one-size-fits-all implementation approach here. Cities, and we would recommend cities begin discussing ordinance updates with their city attorney now, and consider things like appeal procedures, filing deadlines, hearing procedures, findings of fact, decision forms. This statute does not tell councils what factors they should consider when reviewing appeals, so local procedures become especially important here. This is one of those bills where the legislature answered who hears the appeal, but not how the appeal should actually work. So I would expect this area to evolve as cities begin implementing the new law, and eventually as courts interpret it. All right, moving on to election administration reform. This was a pretty big, large package on Iowa's election laws, making clarifying definitions for Election Day. But the big thing here for us is that the law now centralizes all city and school election nomination filings, objections, and related processes within the county commissioners of elections. So removing the duties from or the ability to deputize city clerks and school board secretaries for the purpose of collecting and filing election paperwork. So that's really the big thing for our purposes as it relates to this bill. All right, moving on. So in general, this is a big bill that makes various changes to Iowa's alcoholic beverage laws, wine permitting compliance requirements. But for our purposes, this bill authorizes cities to establish social districts by ordinance, allowing the possession and consumption of alcoholic beverages within designated public areas under specific boundaries, under permitted days and hours of operation. You have to specify the container requirements and participating licensee requirements. But this is generally an expansion of what we're allowed to do. So I've heard of a few communities looking into this one already. I think more or less as it relates to farmers markets in their community. But if that's something you're interested, I would encourage you to read up on this one a bit more. All right, we'll move on to E-Verify. This new law requires the use of E-Verify and SAFE systems for employment and professional licensure eligibility. So cities, counties, school districts, and state agencies are now required to use the federal E-Verify system to check for employment eligibility in the United States. Importantly, it's if you find results indicating a lack of legal status, that is now required to be reported to federal immigration authorities. We've received a number of questions about volunteer firefighters and reserve officers. Our current understanding is that the employment verification requirements apply to employees, not true volunteers. So if a city has questions about a particular position, we do recommend consulting legal counsel because these classifications do vary. Also of note, the E-Verify system is free to use. And from what I've heard from folks on the ground, it can be a little clunky to get your account system set up. But once you do are over that hurdle, it's pretty easy to use. All right, we will move on. Public improvement contract notice requirements. So essentially here, as a requirement for public corporations to send written notice of the date of final acceptance of a public improvement to the principal contractor, surety, and any claimants for labor or material who have filed claims. And this notice must be sent within 14 calendar days of final acceptance. Importantly, the bill does clarify that that public corporations are not liable for any claims or damages arising from failure to provide this notification. We received some questions from our local officials about this. Principal contractor should be interpreted to be the general contractor on the project. Notice must always be sent to the principal contractor and the surety and any claimant that has filed a claim. But if no claims have been filed, you do not have to send it to nobody. But it's the principal contractor or the general contractor and the surety. The recommendation from legal counsel here is to retain proof that the notification was sent. Certified mail may be helpful here, but it's not required. And final acceptance occurs when the city officially accepts the improvement, so typically by council resolution and before retainage is released. All right, divestiture of city mineral rights. We haven't heard from many cities on this bill yet, so if you do think this affects you, I'd be curious to know that. And we think this affects fewer cities than it probably does counties. So the requirement is that cities and counties transfer any mineral interests that they own to the surface owner at no cost within 5 years. Some of our older cities may have retained mineral interest when property was sold decades ago. And while the law does not expressly require cities to conduct title searches, the mandatory 5-year compliance period strongly suggests cities should make reasonable efforts to determine whether they own mineral interests. And the county recorder records are probably your best place to begin looking if questions do arise in your community. Okay, last one here in this section, public employee collective bargaining. So this applies to you if you have any public employee unions. Requires the board to issue a written notice of intent to conduct a retention and recertification election to the public employer and bargaining representatives. The law requires public employers to submit a list of employees in the bargaining unit to the board within 10 days of receiving said notice. The law directs the board to use the submitted employee list to determine election eligibility and outcome, and to establish objection procedures regarding the notice or employee list. The law makes it unlawful for public employers to fail to provide the employee list as required, and allows any Iowa resident to petition for a writ of memorandus to compel compliance with expedited court process and no need to show individual harm. So again, this is going to pertain to a handful of you. Some of you it will not pertain to, but this is one I would recommend reviewing your procedures on to make sure that you are under compliance. All right, we're gonna keep moving here through to our next area. So government cemeteries. This is a new formal designation of government cemeteries, otherwise previously known as more of that perpetual care cemeteries. And we've had a number of conversations with both legal counsel and the Iowa Insurance Division regarding implementation of this bill. So a few things that we've learned. A city-owned cemetery automatically qualifies as a government-owned cemetery. Cities do not need to adopt an ordinance or resolution in order to make that change happen. Existing perpetual care funds do not automatically disappear. Those existing funds remain subject to applicable statutory requirements. So the previous requirements that they were under, that's what you should continue to do with them. The Insurance Division confirmed government cemeteries remain regulated under Chapter 523 unless specifically exempted. They are exempt from the perpetual care subchapter requirements. Cities no longer need to maintain care funds as irrevocable court-supervised trusts, make future mandatory deposits, submit annual reports, or seek approval before withdrawing funds. Existing perpetual care funds may be transferred into another cemetery fund, but they should remain separately accounted for and continue to be used for the perpetual care purposes for which they were established. Our advice here is, excuse me, cities don't need to rush into making these changes, but you should review your cemetery policies and trust documents soon, and probably with legal counsel to make sure that you are just following the letter of the law here. Pecuniary damages. So this legislation and new law authorizes courts to dismiss criminal charges or ordinance violations if the defendant, with prosecutorial consent, agrees to pay pecuniary damages to the victim and Category B restitution, including court costs. This, long story short, there was a Supreme Court decision at the beginning of the year, I think it came out in January, that would have meant that cities and counties would have been recouping fewer criminal charge costs, fees, if you will, and this legislation reverses that. So this was an effort by legislators to make the law more clear as it comes to those restitution and damages there. And the last one in this section, city official insurance policies. This is really quite technical, really actually cleanup from a bill that I believe passed in 2024. I think House File 2398. So it eliminates the specific legal requirements regarding the beneficiary and use of public officer insurance funds. So by eliminating the requirement for the state to be the beneficiary of a public official insurance policy, cities themselves are able to be the beneficiary and determine how public officer insurance policies are used. Very technical cleanup bill there. All right, we'll move into the next section here, moving along on time nicely. Okay, this bill, local civil rights ordinances, this one moved through the legislature very early in session and was signed by the governor pretty quickly. So the bill limits the authority of local governments to enact or enforce. That was later adopted in the standings bill. Or enforce civil rights ordinances that are broader or different from state law. Additionally, it removes the requirement for certain cities to maintain a civil rights agency, instead making that optional. So previously, city populations of over 29,000 were required to have a local civil rights agency. That is no longer a requirement. There's also several new subsections establishing processes for transferring complaints to the Iowa Office of Civil Rights. So specifically there, it allows any party to request transfer of an unresolved complaint, assuming that it's been pending for more than 12 months, from the local agency up to the Iowa Office of Civil Rights in order to get resolution more quickly. We'll move on. Radon mitigation bill. This is one that they've been working on for a couple years. So requires the state building code to include radon mitigation requirement for single family and two family homes. And specifically for us, it clarifies that municipalities are subject to this as well. So after the state building code change there. So something to be aware of. The idea here being that it is much more expensive to go back and create and put in a radon mitigation system after the fact. So if you do it at build, you're going to save a lot of money. And we have a large radon issue here in Iowa. I can attest to that. I just put in a system myself earlier this year, and it was a couple $1,000s. Local ID prohibition, local ID card prohibition, that is. To be clear, I was not aware of any cities that did this. I believe there were a couple counties that did have local ID cards, but that is no longer allowed. And everyone must just use the state ID card moving forward. Security alarm systems. So this bill prohibits cities and counties from treating qualifying battery-charged security alarm systems as fences. So, i.e., like regulating them as under fence codes or requiring fence permits for the installation of these alarm systems on non-residential properties. So specifically, this does not apply to residential. But importantly here, localities may require an alarm system operator license or permit for these systems only as they do other security alarm systems. No additional or different licensing requirements are permitted, but we can't require a fence permit for something that isn't a fence and it is in fact an alarm system. Flag display requirements. This essentially says that public buildings with a flagpole must fly the United States flag and Iowa state flags. And if the governor issues a proclamation about lowering flags to half-staff, cities and counties are required to be in compliance with that. This follows a situation last fall following the assassination of Charlie Kirk, where we had a county, I think, issue on social media, they weren't going to lower the flag. So this became a political battle, state versus local. So hence this bill and now law was born. This bill here, if you guys remember from last year, we had a really large accessory dwelling unit bill that required cities and counties to allow for at least one accessory dwelling unit on lots with single family homes. This is really a cleanup package, I would say, to that bill. This language was worked on by AARP, who really pushed the bill through the last session, and the Planners Association. So this clarifies that an ADU cannot exceed 1,000 square feet or 50% of the size of the main residence, whichever is larger. And unfinished basements are excluded from that size calculation. It also adds a definition of size for ADUs, specifying that refers to the gross living area of the primary dwelling excluding garages, decks, and unheated porches. So really, this should provide local governments with more clarity that the initial bill law did not provide us. So hopefully this is helpful guidance moving forward. Oh, also there, manufactured homes and mobile homes used as ADUs are required to be converted to real property via a permanent foundation and real estate tax. So another change there. This last one in this section here was our standing appropriations bill, which, just for awareness, is the last bill that we ever see during a legislative session. It often includes just clarifying changes, grammatical, corrections to other pieces of legislation that have passed. But inevitably, it also includes a policy change. And the one that was included this year was adopting the 2023 National Electrical Code with specific exemptions. So you'll see them listed there in the sub-bullets. But importantly for us, the law prevents political subdivisions, so cities, from adopting local electrical codes that are more restrictive than the state code. And moving forward, if the state decided to adopt a new state code, it would require a cost analysis for consumers before adoption. So, FYI there. All right, we'll move on to some public safety laws. This is, I would say, fairly technical. So it allows IPERS and MFP-RSI to provide a member's or beneficiary's legal name and last known city to the state treasurer for location purposes. It also changes the statement period for accumulated contributions and benefits credit from the calendar year to the prior 4 quarters. And essentially, what the big thing I took away from it here is that retirees can still receive a paper check from these retirement systems, but a fee will be deducted from their benefits. So really just acknowledging the fact that paper checks cost a little bit more money, and direct deposit will now become the permanent standard for these retirement payments going forward. Expansion of rights for officers placed on Brady Giglio lists. Let's see here. And in general, if you're not aware, a Brady Giglio list is a list compiled by usually a prosecutor's office or law enforcement agency that contains the names of officers who have incidents of untruthfulness or other type of issues that places their credibility into question. So it's not a great list to be on, to say the least. But essentially this, they have more of an explicit right to petition or appeal if someone is trying to get them placed on this list. So something more for your public safety folks to be aware of. Last one in this section. So this bill, this new law, expands and clarifies the legal exemptions for drivers of authorized emergency vehicles and police officers riding police bikes. So it allows them, under specific circumstances, to proceed through red lights or stop signs and exceed speed limits, which I would love to see an officer on a bike exceed a speed limit. I guess if you were going 25, yeah, but just one here for you to be aware of for your public safety folks. All right, now we have a few just miscellaneous items that I couldn't figure out how to categorize. So this is one you've probably seen something about. I've seen a few news articles about it. So this raises the default speed limit for vehicular traffic from 55, which was the previous standard, up to 60. And it does allow agencies to use temporary overlays or stickers to update the speed limit signs while those permanent signs are being ordered and installed. So you've likely already seen some of this happen across the state as this went into effect July 1st. And this shouldn't affect, this doesn't affect in city speed limits, but I did think it would be useful for your communities that you may have on either side of your community the default speed limit leading into it. So just to be aware that you may have higher speed cars coming through that need to slow down. So you may want to watch out for that. We also have a junior firefighter program. This authorizes elective firefighter programs for 11th and 12th grade students. This is optional for the student, it's optional for the school district, but it requires schools to enter into agreement if they decide to go through with this program with local fire departments in order to provide training, supervision, and to define permitted and prohibited activities. Let's see, we did get in here that it clarifies that the participation does not create an employee, volunteer, or fire department member status for students, so it does not entitle them to any kind of workers' compensation. But what's cool is that it allows students who complete the program and meet the requirements to sit for the Firefighter 1 certification tests. And if they pass it, they get that certification. If they pass it before they turn the age of 18, their certification will be issued once they turn 18 years old. But the idea here is really that most of our state is covered by volunteer firefighters, and it's a dwindling population of folks that are willing to go into this field. So if you don't have firefighting in your family, you may not really know that this is an option. So I know our friends at the Firefighters Association thought this would be a good idea just to get more volunteers into the field. So happy to see that one move forward this year. Abandoned vehicle law updates. So this has been an effort up at the Capitol for a few years now. This really institutes broad reforms to abandoned vehicle procedures. The bill updates notification timelines, allows for credit card payments when releasing a vehicle. It establishes new processes for lien holder inspections and owner retrieval of personal property. It requires fee transparency and asserts, and specifically for us, it asserts state preemption over local ordinances regarding abandoned vehicle towing. Like I said, this has been an effort by some advocates at the Capitol for a number of years. The towing industry has largely been an unregulated industry, so this is really seen as a consumer protection effort. I know some folks were happy to see this one get to the finish line as well. And then we have the constitutional amendment. This does not necessarily directly impact city governments, but I did think it was pertinent just to be aware of for you as municipal local leaders, but as well, this will be on your ballot this fall as well. So there will be a question on the November ballot for all Iowa voters that asks if they support requiring a 2/3 supermajority vote in both chambers of the legislature in order to pass a bill that raises state income taxes, essentially. Does not apply to local governments, but just know it will make it harder for the state legislature to increase state taxes. So again, just something to be aware of. You can share with your constituents perhaps, or your families even. Okay. Now let's get to the questions. I've seen the number continue to populate.
Yep, I'm keeping track for you.
Okay, thank you,
Uh,
Mike.
so to go back, I believe, to the public meeting notices,
Mm-hmm.
there was a question where a city, their library has a separate website. Do they need to post to just the main city website, to the libraries, to both?
Based off of and I think Grace is on here too, so you could chat me if you think I'm wrong, Grace, who's been handling this for us. Based off what I saw in IPIB's guidance, it's the primary internet site, so that's what's required. So you're more than welcome to publish that information, put that information on your library website as well. But I think the city's website is what's specifically required.
Yep, so the body must annually designate a location for such purposes by the governmental body, is what Grace added.
Thank you, Grace.
For the flag bill, um, we are a 28E Council of Governments. Does the flag requirement apply to them as well?
I believe the way that the law is written, it's a public. If you have a public building, I believe that's the designation.
Okay.
Going back to see if I see something else. And I will say before, Mike, you move on to the next one, feel free to follow up over email as well. I may be able to help a little bit better that way. But yeah,
Yeah.
it's public.
Um, is that every public building or just one per city?
Public buildings with flagpoles, I would say.
Okay. Um, we have several about the ADU bill.
Okay.
Um, would this mean new ordinance changes if we had already updated our ordinances with the initial ADU bill?
Depending, I guess, depending on how detailed the ordinance got, already, you might want to look at revisiting. Yes. Um, this is really supposed to help be more specific for you for calculation purposes of how big the ADU can be. So I would encourage you to at least review it and see if it's necessary to update. Yeah.
Okay. Um, Similarly, what if ADUs were already approved above the max size?
ADUs were approved above the max size. Oh, I see what you're saying. That's a good question.
That's one for the lawyers and
Yeah, that's a great
yeah,
question. That's a great question. I would say consult your legal counsel on that. I'd also say it's probably going to be hard to revoke that approval,
yeah. And
unfortunately.
I will say, as Chelsea mentioned, if you need more details, we're certainly happy to help do some research and you can reach out to us afterwards.
Yeah, absolutely.
Um, our city does not allow manufactured homes. Will the ADU bill override that?
I would need to go back to the original ADU bill, because I don't think that change happened in this year's legislation. I think that would have been made more clear. I think that would have been made clear in the 2025 bill, and I don't remember that off the top of my head. Manufactured
Um,
homes. I almost think. No, I don't want to say that. Okay. But I can check that. Can you note who that was by, Mike, and I can
yeah.
follow up. Okay.
Um, we have one other content one, but first we've had several questions. I will be sending out the recording and the report. in the next few days. Will you make this slide deck available?
Yes, I can make the slide deck available.
Great. So that'll be in a follow-up email to everyone who registered. Um, is the public notice for council meetings only, or do you have to do Board of Adjustments, planning and zoning, all that stuff on the website?
Mhm. Grace, do you know the answer to that one?
Grace says all governmental bodies.
Thank you, Grace. She's been reading this bill a lot the last couple of months, you guys. Thanks,
Yeah,
Grace.
if you have questions about open meetings and records, Grace is the person for you.
She's your go-to.
These are the questions I've seen. Does anyone else have further questions to put in the chat or the Q&A?
If not today, I think we've said this a couple times now, but please don't hesitate to reach out over email or phone. Um, we're happy to answer the questions we can, and if we don't have the answers, we can certainly point you in the right direction. Usually, for where to go. And as I mentioned at the beginning of the presentation, we will continue to share guidance with you guys as more of it becomes available. Um, I I like doing this we usually do this before July 1, but I did want to wait until we got a little bit more clarity from some of our state agency friends on some of these bills. But we'll continue to get more information. So we will certainly put more information out via Leak Weekly or other kinds of push notifications. Okay, well, if nothing else, I'm gonna stop sharing this real quick, and instead, if I can do this. I have a code. I have the codes for you guys. Oh, and my computer's frozen. That's great. Okay, so I'm going to start with IMAA, and I'll put it in the chat here too. And then I will screen share. For IMFOA. So you have 30 minutes to get this in. Otherwise, thank you guys so much for joining. I hope this was helpful, and continue to let us know what your questions are, how things are going, if you run into any hurdles. Thank you, John. All right. Thanks so much, you guys. Appreciate it.
All right, everybody. I'm gonna shut this down. So last chance to take a quick screenshot of that, and then we will send you all on your way. All right, thank you, everyone.